Welcome to this FedSoc Forum webinar call. Today, May 22nd, 2024, we're delighted to host a discussion on navigating the FCC's digital discrimination rules. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we'll keep the introduction of our guest today brief, but if you'd like to know more, you can access their impressive full bios at fedsoc.org. Today, we are fortunate to have with us as our moderator, Danielle Thuman, who is Senior Attorney in Government Relations at Crown Castle. Before joining Crown Castle, Ms. Thuman served as legal advisor to Commissioner Brendan Carr at the FCC. Previously, she also worked as communications attorney in the Washington, D.C. office of Wilkinson Barker Knarr, LLP, focusing on a wide range of regulatory, policy, and transactional issues with a special emphasis on infrastructure, public safety, and spectrum policy. I'll leave it to her to introduce our panel. A last note, and then I'll get off your screens and let us get into the discussion. If you have questions, please submit them via the question and answer feature found at the bottom of your Zoom screen, so it'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Ms. Thuman, the floor is yours.
Thank you so much for the kind introduction. I'm excited to be moderating this wonderful panel of speakers. So first we have Diana Eisner, who's Vice President of Policy and Advocacy for USTelecom. Diana joined USTelecom from Frontier Communications, where she previously served as Director of Federal Regulatory Affairs and helped develop the communication company's regulatory strategy on broadband deployment, robocalls, and cybersecurity. Prior to that, Diana was an associate attorney at Mannett, Phelps, and Phillips. She is a graduate of Rutgers University and earned her JD from Temple University Beasley School of Law. Next, we have Denny Law, General Manager and CEO of Golden West Telecommunications. Prior to becoming GM and CEO, he was Eastern Region Manager for Golden West. Prior to that, Denny served as General Manager of Sioux Valley Telephone and Hills Telephone Company. Denny graduated from South Dakota State University and went on to obtain his master's from the University of South Dakota. We also have Elisa Valentin, Broadband Policy Director at Public Knowledge. Before joining Public Knowledge, Elisa was the Senior Director of Technology and Telecommunications Policy at the National Urban League. Elisa previously worked as a special advisor to FCC Commissioner Jeffrey Starks and as a Communications Justice Fellow at Public Knowledge. She is also an adjunct professor at Norfolk State University. Elisa received her PhD in communications from Howard University, her master's in journalism from Northwestern University, and her bachelor's in telecommunications from the University of Florida. So thank you guys so much for joining us. Elisa, to kick us off, can you talk a little bit about the goals of the FCC's digital discrimination proceeding and the history leading up to the adoption of Section 60506 of the Infrastructure Investment and Jobs Act, or IJA, as we'll refer to it over the course of the panel?
Yeah, sure. Thank you so much for having me join your panel today, Danielle. I really appreciate it. So the history here for me starts with the fact that there are places in the country that have been left behind, right? And that don't have access to broadband, don't have the same adoption rates as other parts of the country due to lack of investment. And that is in communities like Selma, Alabama, or Beattyville, Kentucky, or Colonias that are on border towns in Texas. And when you look at studies of who does and who does not have access to broadband, the disparity that really, pops out is the fact that low-income communities and communities of color don't have access to broadband at the same rate as other communities. And a lot of these disparities mirror historic redlining. So I see the digital discrimination rules as an opportunity to not necessarily right the wrongs of the past because the rules aren't retroactive, but looking at the future, because the fact of the matter is the more of us who are connected to broadband, we all benefit, right? And digital discrimination rules really present an opportunity to really shape the behavior of providers as well, and also offers opportunities with model policies for localities and states to also find a way to increase broadband adoption rates and broadband access that communities who have historically been at the margins are not continuously left behind. But I would also just add that digital discrimination rules that fits into the broadband provisions of the infrastructure law, right? Because Congress said, and quote, access to affordable, reliable, high-speed broadband is essential to full participation in modern life in the United States. And they also noted, Congress noted, that the digital divide disproportionately impacts communities of color, lower income areas, and rural areas, and the benefits of broadband should be broadly enjoyed by all. So we're here because of Congress through the infrastructure law on a bipartisan basis. And, really they're aiming to fix all parts of the digital divide, whether you're talking about affordability or access or adoption, but equity is at the center of all of that. And I know that right now the word equity is getting a little bit of a bad reputation, but, ultimately to me, it's about opportunities, right? And also the barriers that are kind of in some folks' paths. And at the end of the day, we should make sure that we're removing barriers so that people in Hazelhurst, Georgia, or Baltimore, Maryland, or South Louisiana aren't burdened because of where they were born or the circumstances that they were born into. And again, this is about making sure that all of us thrive, no matter our geographic location, no matter our race, no matter our income level.
Thank you so much. Diana and Denny, can you guys give a little bit of an overview of the involvement that your association and your company have each had in the proceeding over the last few years, and the perspectives that you bring to the table? Diana, if you want to go first, that would be great.
Sure. Thank you, Danielle, and thank you to Federalist Society for having me. Really happy to be here and talk about this important issue with all of you. So USTelecom has been involved in this proceeding for, as you said, Danielle, the past few years, starting with the NOI. And for us, I think it is really important to remember that broadband providers who are our members have an incentive to connect as many people to broadband as possible. That is their business. Their business is connecting communities, and that is what they are trying to do. And I think that we really need to acknowledge that the broadband marketplace is vibrant. It's increasingly competitive, services being turned up at new locations every day, and providers are investing more than ever in their networks, including a record $102.4 billion in 2022, and that was just in private investment, not even federal dollars. Light touch regulation of broadband has worked. Imposing really stringent, wide-ranging regulatory frameworks like these rules could very well take us backwards. And we really believe that the best way to facilitate equal access, which is the Commission's charge in Section 60506, is through positive policy changes to incentivize deployment, such as removing permitting barriers, getting rid of outdated regulations that require providers to dump capital into underutilized legacy networks, ensuring a stable USF base to support the highest cost areas of our country. And that's really, to us, how we get to this goal of connecting everyone.
Well, Danielle, thanks for inviting me to join this important discussion today. I'll give you just a brief description of Golden West, and then I'll bring it back to more of a higher level in terms of Golden West Telecommunications Cooperative is a rural-based telecommunications provider. I'm in South Dakota. We are, as I mentioned, a cooperative, which means we are owned by our members. The people that we serve are our actual owners. We serve rural areas in South Dakota. The largest community we serve has roughly 4,000 people in it. That's the largest community that we serve. But we serve a geographic area that's the equivalent of Maryland, New Jersey, Delaware, and Connecticut combined. That's the geography that we cover. And so I'll use that backdrop from Golden West perspective as a larger umbrella, so to speak, as our involvement in NTCA, the Rural Broadband Association, which represents roughly 800 providers similar to Golden West across the country. And we serve rural and remote areas, primarily either cooperative or privately held, family owned in most cases. And we serve roughly 30% of this country's geography. So when you talk about hard to reach areas, that's, I'll say, in our wheelhouse and in other NTCA member wheelhouses. And our goals have been the same for many years, which has been deployment and advancement of broadband capability throughout our service area and throughout other member company service areas. The discussion today on digital discrimination certainly, I'll say, has an impact, but our overarching goal has always been to provide service to all, and I would capitalize and underline the word all, of our members.
Thank you. So as you guys previewed a little bit already, the FCC just adopted its rules in November. And as part of the report and order stemming from the FCC's proceeding, we saw the FCC conclude that Section 60506 of IJA authorizes a disparate impact liability standard. And so this standard is then incorporated into the FCC's definition of digital discrimination of access. For our listeners, can you explain what is the disparate impact standard and why has it been an important part of the conversation?
So I would define the disparate impact standard as meaning that a provider could be in violation of the FCC's digital discrimination rules. Even if it has uniform policies, it applies consistently across all of its service areas. It does not engage in intentional discrimination, but those policies have an incidental effect on the protected classes enumerated, or one of the protected classes enumerated in the statute.
Elisa, public knowledge has been very vocal about its support for this standard and the adoption of the rules over the course of the proceeding. Can you talk a little bit about why this standard is so important to public knowledge and why, from PK's perspective, the FCC got it right?
Yeah, so, Congress stated that, its policy is that all people of the United States should benefit from equal access to broadband service. And from our perspective at PK, this language is really similar to the Communications Act of 1934, because when Congress created the commission, it said that they should make available so far as possible to all people in the United States communication services. So we really feel like that mirrors, right? But over the years, the commission has relied on that directive to adopt rules that promote access to, basic phone service, to mobile services, to cable services and broadband. And over time, those rules and policies haven't focused solely on intent, right? Instead, the commission has focused on advancing policies to ensure that providers of these services make their services available to all people, right? So Congress, told the commission that you must, affirmatively ensure that equal access to broadband services, is available. And also, I think that directive really focuses, beyond a provider's sort of intentions. And I think that if you were to focus just on disparate treatment, right, or that intentional discrimination, you would be forced to kind of find like a smoking gun, right, of an email that says like, we will not deploy to X community because of X reason. Like, we're not going to find that sort of smoking gun. And so I definitely think that this was the best approach here. And then also seeing, people who have worked on, disparate impact so much over the years in the civil rights community, speak about it as well was also, really amazing to see. And I'm sure that's probably the only time that you were to hear a round of applause for a disparate impact when Chair Rosenworcel announced it at UCC last November at the Everett Parker Awards, because everyone in our community, in the public interest community, as well as in the civil rights community, were so excited to hear that the FCC had adopted the standard.
Great, thank you. Denny, do you have anything that you'd like to add on that point?
Not
No?
additionally.
Okay, I think that brings us, go ahead, Diana.
Sorry, I wanted to, I think it's really great Elisa mentioned the Communications Act, because, from our perspective, we need to remember that Congress is very intentional in what it does. And Congress did not incorporate Section 60506 into the Communications Act, which is one of the reasons that we think that the rules put forth, and we can get into that more in detail, just really are not going to hold up and really are very concerning, as well as the adoption of the disparate impact standard.
Great, thank you. I look forward to unpacking that a little bit more in a few minutes. So let's turn next to the definitions of technically feasible and economically feasible. So in the FCC's report and order, these definitions the FCC defined these terms to mean reasonably achievable as evidenced by prior success by covered entities under similar circumstances. This definition could be very difficult to navigate in the real world. How is USTelecom advising its members on whether or not deployment and network maintenance or upgrades are reasonably achievable?
So as an association, we don't provide compliance advice to our members, but happy to give you all my take. So our take is we read the order as requiring a provider show infeasibility, so that no other providers had success, as opposed to, for example, being permitted to provide a reason why a decision not to deploy was made based on the particular needs of that provider. We think that this requirement, that it is specific to the provider, not any provider, is inherent in the statute based on the language to take into account technical and economic feasibility. We think that the commission's interpretation really creates a bespoke framework, unlike anything that we've ever seen, and also just turns it on its head. And part of the reason that the technical and economic feasibility is so important, and with respect to the deployment and network maintenance and upgrades issue you had asked about, every provider is different. They face different capital constraints, have different risk tolerances, business models, et cetera, even if they're of the same size. The statute tells the commission to take that into account. Just because one provider made the decision to deploy in a certain area doesn't mean the same decision would work for another provider. And we just don't think that the commission recognized this, and that this is going to create huge, huge hurdles for providers and just not be workable in this environment, and with every provider being so unique.
Denny, you talked a little bit about coming from a rural co-op earlier. I think that you have a very unique perspective to offer here. Is one other provider's experience enough to make deployment or network upgrades feasible, or how is Golden West viewing this requirement?
You know, certainly our experience that it is entirely unique to individual entities, and sometimes even within an individual entity such as Golden West, it's unique how we may have done something or why we may have done something in one geographic locale. Network topology, geographic topology, what have you, could be entirely different in one area comparative to a different area within our same service area. Now, if you layer on, I'll say what I'll call a neighbor, an adjacent provider, or provider even within our own scope, but an adjacent provider or other providers of similar or like size or capabilities, it's not comparable. I mean, there's zero comparability to that, whether that be funding, whether that be network, whether that be engineering practice, all of those items. Network design, just to give you an idea, Golden West has been on a path to replace our copper network with fiber optics on 100% level. We began that process in 2007. We're still working on it. We'll get to the finish line here within the next couple of years, we hope. But even over that period of time, and so when you start talking about what was reasonably comparable for someone else or another network provider to accomplish comparative to what we may or may not have done, it's not, apples and oranges. It's apples and Toyotas. It's not even in the same category. And I would be very hesitant to use Golden West experience to compare to some other provider if they were being asked that, and I would not want to be compared to in our practices to someone else.
Elisa, do you have anything to add or any response?
Yeah, I mean, I think the only thing to add, and I'm sure we'll get into it here shortly, is that, of course, the devil is in the details here. And I think that we'll see more when enforcement takes place. I think that's where we're going to learn more about the direction that this goes. So, yeah, but I believe in the very smart and capable people at the commission where we were both working at to guide us along here.
So you just mentioned enforcement. Let's talk enforcement and the FCC's investigation and complaint process. Do we have an understanding yet of how the FCC is going to be enforcing these rules and investigating providers for compliance?
From my perspective, we don't. And that's part of what's so concerning with this whole order. These rules have an unlimited scope. They reach each and every aspect of a provider's operations, from advertising to service suspension, and with no idea of what compliance looks like and no sense of how the FCC will enforce, we don't even know what the penalties would be. Because this is not part of the Communications Act, the commission wouldn't seem to be limited by the $15,000 per violation. The order gives no sense of, if there's a cap on penalties, what penalties might be. So it's really a very scary prospect, but we need to continue to incentivize investment. And I'm hoping that the commission will continue to try to do that with its enforcement and investigation powers. So it should really use these powers sparingly and really only require provider responses to complaints where circumstances warrant it. Unlike the commission's existing complaint process, where you have to be a customer of the provider to file a complaint, this is a potentially unlimited universe of who could file a complaint. There's no requirement that you be in the provider's footprint. There's no requirement that you actually be a consumer. So this could lead to an unlimited volume of complaints coming in, and those complaints should only be answered by providers when necessary. And the same thing with enforcement. The commission should really only move to enforcement in the most egregious circumstances, such as intentional discrimination, which is what we believe is the only type of standard that's authorized under the statute. Otherwise, you're going to be distracting providers from what their real job is. And their job is get these networks deployed and keep them running and keep your customers connected.
Well, so I know we plan to talk about compliance challenges a little bit further down the line, but do you anticipate that companies will be setting up individuals or groups to be reviewing these complaints? Or what do we actually anticipate from industry in terms of responsiveness to investigations and complaints?
I think, as industry always is, it will be responsive and cooperative with inquiries from the commission, and the same way that it responds to FCC complaints now. But I think the whole goal here would be not to have companies set up entire groups of employees whose only job is to review these complaints, especially when they could be entirely frivolous. We don't know yet. And I think part of this is companies are really trying to work through what compliance looks like, having no roadmap for it, and this being just such a completely bespoke framework in so many ways that we don't yet know. And we're really hoping that the commission will be very judicious in how it actually administers these rules and the whole process, so that providers aren't in the position of having to take resources away from deployment to pay employees who are going to sit and review FCC complaints all day.
And if I could just add, I'm sorry, go ahead.
Go ahead. Nope, that's fine. Go ahead, Denny.
I would only add to that from the small providers perspective, and my colleague Ms. Eisner USTelecom has small providers as part of their membership as well. It's not as though a company like Golden West, and we're large within the small space, meaning we're a small company by every metric and measure. At the same time, an average rural broadband provider has 20-ish employees probably. It's not like we have a compliance department that this is going to land in. And so even if there is, whether it is an allegation, investigation, or otherwise, it is going to, what I term spin cycles. It is going to spin cycles from a regulatory perspective, hiring of consultants, hiring of advisory council, internal perspectives to fill that data and whatever those requests may be. And I see this being the potential for an endless rabbit hole to run down. And that's concerning for us. That's a tremendous risk for us.
It's a really good way to put it.
Danielle, can I jump in? I'm kind of backtracking though about the enforcement question, if you don't mind.
Sure.
So I do think, like, just on the point about, enforcement and the Communications Act, from what I understand, in the past, the commission hasn't hesitated in various instances, if it's not, the Communications Act is kind of not expressly, stated or amended, to still use its Section 5 authority and to treat these statutes as kind of part of the Communications Act. And I know that, most recently the commission considered and rejected that exact challenge to its enforcement authority with the broadband label rules. And I also would just say that, the commission did say in their rules that they're going to use the kind of full gamut of their enforcement toolkit here, right? Which ranges from, of course, the letters of inquiry to to remedial orders, to forfeiture proceedings, and all of that. And the commission said that they're going to rely on self-initiated enforcement scheme. But I do want to offer up something that public knowledge really wants to see that we think could actually help the commission in these efforts, which is that we want to see the commission stand up in Office of Civil Rights in order to coordinate that informal complaint process, not only for the folks who are filing those complaints, but of course, like with the providers as well, right? To really offer up a place where folks can have those robust discussions, right? To figure out what the path forward needs to be. And that's something that quite a few of us have advocated for, and that we're going to continue to advocate for, because we don't want this these rules to kind of fall by the wayside, you know, when it comes to like future commissions. We want it to still be a major priority.
Thank you. Do you anticipate seeing the FCC provide more guidance on the complaint process, or has that been teed up in the notice that accompanied the RNO?
I don't think
When
so.
you just said that you continue to advocate in front of the FCC
So
for
the
this.
Office of, so that we continue to advocate for an Office of Civil Rights, because that was teed up in the FNPRM. The question
Got
of
it.
should
Okay,
that-
that's what I was asking.
Yeah.
That's what I was
Okay.
asking, if it was
Yeah,
still
yes,
open. Yeah, yes. And
Okay.
if it was
Yes.
just still open before the
Yes.
FCC in the notice portion. Okay,
Yes. Yeah.
got it. Okay, jumping back a little bit, Elisa, you had mentioned the model policies and best practices earlier. So the FCC did adopt these model policies for states, localities, and tribal governments. I'm curious what you guys are seeing in terms of conversations across states on how states or localities may be addressing digital discrimination. Denny, if we could start with you in South Dakota, that would be great. And then we can turn to Diana and Elisa if you have anything to add.
You know, I'll say directly as it relates to digital discrimination, I've not seen those discussions up to this point. And I think that's probably for a couple of reasons. The primary reason is, you know, South Dakota being large geographic, but small in terms of population. The focus right now is on, you know, availability, which is probably maybe an overarching part of the digital discrimination aspect. But in terms of where are the pockets of unavailability remaining in this state? How do we accomplish that? Whether it is upcoming BEAD money, whether it is current providers, all the different tools in the toolkit right now for that. But in terms of specific digital discrimination discussions, I'm not aware of anything along those lines, at least where I operate.
Diana or Elisa, anything to add on that?
I would just
would-
say, oh,
Go
go
ahead.
ahead, sorry.
No, please go ahead.
I would just say that, like, you know, states and localities are really the folks who know what's going on, like on the ground, and their voices really matter. And you know, with the advisory council, the CEDC that the commission has, you know, during the kind of the last sort of like iteration of the advisory council, there weren't enough of those voices on that council, and now public knowledge is a part of it, and that's something that we're going to make sure that, you know, we continue to try to find ways to lift up those voices, because we all know there needs to be increased coordination, right, between, you know, the federal level, states, and localities. And I think that's going to be, you know, really important going forward.
And just, you know, to add on to what Denny said, you know, from the more national perspective, I'm also not really aware of states that are really digging into this. And I think that's in large part because we have BEAD coming, and BEAD is such a huge opportunity. And I think that states are rightly focused on, let's get our BEAD dollars out and let's get these unserved and underserved locations served. And then, you know, we may not have a problem here. I mean, we firmly believe as USTelecom that digital discrimination is not a thing. It's not occurring. It's not happening. Providers make deployment decisions for many reasons. None of them have to do with animus. They make their decisions on a, you know, race, income, gender, everything blind basis. So let's really focus on BEAD. And I think that's where the states rightly have their focus right now. Let's get everyone connected.
So do you see, though, in the conversations that are happening for BEAD in the states, are you seeing conversations about digital discrimination, or do you think that the focus is just on serving the unserved areas?
I think it's on serving the unserved areas. I think that the states, you know, as Elisa said, the states and localities are really the ones on the ground, literally. And they know what the geography is. They know what these areas look like. They know how sparsely populated they are. I think they understand that there are legitimate reasons that these areas don't yet have next generation connectivity. And their focus is on, let's make sure that the circumstances are right to fill in those areas, as opposed to really looking at this as a problem of digital discrimination.
And I do think a couple of months ago, California, I don't remember the person's name, but someone in California introduced a bill to prevent digital discrimination that kind of mirrored some of the things that the FCC is doing. I think it was just introduced. I don't know if it's gone anywhere, but I know California is one example of that, but I can't speak to other states. So yeah.
Okay, great. So we have touched on some of the different facets of the FCC's framework. What are the biggest compliance challenges that you see coming down the pike?
So from my members' perspective, and kind of what I see when I look at this is, and I know I mentioned the unlimited scope, I think that is the biggest hurdle. How does a provider using company-wide neutral policies comply? So I'd mentioned that this touches a provider's advertising. For example, could you advertise at the Super Bowl? Super Bowl is a very expensive event to attend. It's a popular sporting event. It gets a lot of eyes on it. But because it's so expensive to attend, would that be a violation of the digital discrimination rules? Because that could be seen as having a disparate impact on lower income individuals who maybe can't attend the Super Bowl or don't have cable TV and can't see all of that advertising. And another big issue is the elements of service that are covered implicate the same concern. So if a provider is dealing with a technician shortage in an area with predominantly protected classes, does the provider need to slow truck roll times in other areas to ensure parity? Same thing with consumer premises equipment. A provider gets a limited quantity of next generation routers. There's only so many that they can provide to customers. Do they have to make sure that they're giving them out to protected classes, to non-protected classes, to make sure that there's no disparate impact? And I think this all goes to perhaps a larger concern from the provider community, which is providers do not collect demographic data. They don't want to. Are these rules going to force them into doing that so that they can ensure compliance? Are they going to have to start collecting information on income, on race, on things of that nature?
I'll maybe just add, from a compliance perspective, it adds yet another item, and in our case, in already serving hard to serve, difficult to serve, uneconomic, all of the above. What it does is inserts two additional items that I don't have a solution for: uncertainty and risk. And the uncertainty and the risk, in addition to the uneconomic aspect of it, make it incredibly challenging. And when I read in the order about the full force of the FCC's enforcement capability, I don't get a warm fuzzy from that. And the reason I don't get a warm fuzzy is, look, am I comfortable with the decisions that we have made, that I have made, as it relates to deployment and services and capabilities and pricing and all those items? Absolutely. Even the mere thought of an inquiry, just an inquiry or a complaint, will cost us time, will cost us money, will cost a diversion of resources that I don't have. And so I'll say that overhang introduces a challenge for small operators right out of the gate. And while there's a presumptive belief inside of the order regarding, we're a universal service fund recipient, there's a presumptive belief that we'll be in compliance. There is no safe harbor, however. And so, it's I don't want to say that's a hollow, but it's not exactly I'll say a warm fuzzy feeling for a provider such as mine. To give you one anecdotal item, our insurance providers, our general liability insurance providers, have reached out to us to ask us about this order, because they insure us. And so now, in the event there is a claim, in the event there is an enforcement action, am I going to see that in, some type of reflection of that in my upcoming liability rates? I don't know. I certainly hope not. But this definitely introduces uncertainty and risk in a already uncertain and risky business.
Well, and to piggyback on what Denny said and also what Elisa said about the full force of the FCC's enforcement abilities, I mean, are we looking at deployment mandates? Are we looking at the FCC saying to a provider, you should have deployed in this area, even though, there's already a different competitor there, but you didn't build fiber there. So we're going to tell you that you now must deploy there to remedy the situation. It's really uncertain. And I think that creates a lot of fear for providers and, where do I invest? What do I invest? How do I do this?
Elisa, do you have any reactions to those compliance challenges?
Yeah, so, in my opinion, the commission was really guided by the fact that this is a consumer focused statute. And the goal here, is to not make, highly formalistic sort of like requirements for providers, right? It's to make sure that we aren't leaving people behind in the information age. And, I'm glad that the commission didn't just focus on deployment. As I know some folks, advocated for that, because then I think that we wouldn't have been able to, address barriers to adoption, like price and like quality of service, which is also important for making kind of meaningful comparisons of offered services. And as it relates to kind of non-technical services, public knowledge did, advocate before the commission that, actual and advertised service prices and, technician responsiveness, the availability and advertising of promotions, additional fees, that those should all be looked at as well. And, we said this because, if the actual kind of quality of service or terms and conditions of the two services differ so substantially that they're no longer comparable, then the customer doesn't have equal access. And so when a community has, slower, or kind of more lagging kind of broadband, they're a victim of digital discrimination, right? If they experience more outages or, a higher price, they're likely a victim of digital discrimination. And so again, this is just about making sure that we're finding innovative ways to promote equity, because we all do benefit.
If I could just respond to a moment to a couple of comments that Elisa made. You used a couple of examples toward the end that I think are probably examples of my concern, which are a community that is subject to perhaps a slower capabilities or something along those lines is a victim of digital discrimination. I'll give you an example. So we have multiple communities within our service area. Some of them, we have multiple generations of electronics throughout our network. Some of the stuff we did, as I mentioned, we began in 2007. It's now 24. We're still going forward. We've probably got most of the 2007 electronics out, but we have 2011, 12, 13, 14, 15 electronics in there that don't do anything necessarily comparable to what the services are that are available today on I'll say the new gen equipment. But our focus is on deployment at the moment and getting fiber to the various premises, to all of our premises. Am I then liable from a digital discrimination issue? Because I live in Wall, South Dakota, so I'll use Wall as my example. So Wall's running on 2015 generation equipment. Now other communities are running on 2024 generation equipment. Is Wall, the community I live in, being digitally discriminated against? And I use that as a hypothetical, but that's the type of navigation uncertainty that providers like I have.
Denny, you mentioned that there's a presumption of compliance for USF recipients. Does that presumption extend to companies that are receiving BEAD dollars, since there is an obligation to build out to 100%? Or do you?
My understanding is that the BEAD and USF were, if I recall correctly, BEAD and USF dollars are treated similarly in terms of obligations. But again, don't confuse it with a safe harbor. It is not.
Okay, the commission was very careful not to use the language safe harbor, despite the urging of many. And so essentially what it is there is a presumption of compliance if you deploy consistent with your obligations under your USF program or under the BEAD.
Okay, that's very helpful. So turning next to the notice that accompanied the report and order, the notice sought comment on additional obligations, including new annual reporting obligations for providers pertaining to deployment projects and upgrades, as well as setting up internal compliance programs. Replies were filed last month. Can each of you talk a little bit about the notice and the potential advantages or disadvantages of these additional obligations?
So we think that the notice goes far, far beyond what the statute allows. We are very concerned about these proposed requirements. So going beyond the scope of the statute, the annual reporting is just unnecessary given the BDC. Providers already report on availability, which also means they report on upgrades, because an upgrade typically means you're getting a higher speed. And the BDC was a massive effort by the commission. It took years, and we're still working on it. It's an iterative process, but we should be relying on that. And providers put a tremendous amount of effort into the BDC reports. They require a lot of manpower, a lot of effort, a lot of resources. We should really be relying on that. There's no reason for providers to have to do a second round of reporting specific to this. And the other issue is that this compliance program would be an unprecedented intrusion into how companies operate. The further notice lays out all of these different requirements that the commission is contemplating in a compliance program, including, how having a committee, how you report to senior management. I mean, this is really dictating how these companies operate. And companies, same reason they choose about their deployment decisions, companies need flexibility to craft their compliance in a way that works for their specific needs. Every provider is different, and a one-size-fits-all approach won't work. And again, without any evidence that there is digital discrimination afoot, requiring companies to implement these stringent compliance requirements is just such an intrusion into the way they operate. And it's going to be a distraction from the business of deployment and keeping customers connected.
I'll pick that up next, and I'll add on to a couple of the items that Diana mentioned. So Diana mentioned the BDC filing. That's one. If you're a USF recipient or an eligible telecommunications carrier, which Golden West and most of the small rural telecommunications providers are, we have what's known as a Form 481, which is part of our ETC filing, which is in many ways, but not entirely duplicative of the BDC. There's some nuances there. So that's 1 and 2 for us. This would be 3. That's just from the reporting aspect of it. The other concerns with it are really probably twofold from my perspective. One is there is a competitive aspect to this, which is for public disclosure, now releasing both current as well as future network architecture plans, upgrades, all those items. It doesn't, that's not the type of information we typically publicly disclose. We don't, and we're rarely, if ever, even asked about, I'll say, some of the technical detail that's contained in the further notice as it relates to our network. That's item 1. Item 2 is, I will tell you, I don't mean to, all of you have done various levels of public service, and I do not mean to speak negatively of folks who have done public service in terms of FCC work or otherwise, but this was very clearly written by someone who has never operated a network before. Because when I read the comments about every deployment, upgrade, and maintenance project undertaken during the prior year, we're a little company. We do thousands of maintenance projects, and we do thousands of upgrade projects. We do dozens of deployments. So deployment I get, but as was mentioned, we do that in both the BDC as well as the ETC. But in terms of maintenance and upgrades, we do thousands of those. Is it maintenance and upgrade of what? The electronics? Which electronics? The electronics in the home? We have over 100,000 devices we support in customers' homes. They are all at various levels. They have a software load. It's no different than, I'll say, you with your iPhone or your whatever phone you have and upgrading the iOS on it. Same thing. We push those upgrades out all the time. We are constantly doing that. You now want me to report on when I do those maintenance. In terms of upgrades, what's going to qualify as an upgrade? Is it an edge router? What part of the network? Middle mile? Last mile? Which mile is it? I will tell you, while I'm disappointed in the digital discrimination order as a whole, from a provider perspective, when I read the further notice, it doesn't give me much comfort.
Yeah, and if I could just jump in here, Danielle, I think, what the commission is trying to get at here is that word of prevent. Like, how do we prevent digital discrimination? How can we have some affirmative obligations so that, maybe it's not you, maybe it's not your member companies, right? But, you know, how can we make sure that we're not engaging in this behavior in the future? And I think on the compliance, you know, issue in particular, you know, we would agreed with other folks in the civil rights community, who said that ISP should file an annual certification with the FCC, you know, signed by an executive of the company with responsibility for the provider's compliance, that says that, you know, you are in compliance with the FCC's digital discrimination rules, right? And we think that that kind of mirrors, you know, the CP&I rules and also like accessibility record keeping, and that the certification process in our minds is a way to be able to kind of promote, you know, ethical behavior and mitigate risks that, if unchecked, can negatively impact protected classes. And I also think too that, you know, and I don't, you know off the top of my head all of the comments that were submitted and what you all submitted as it relates to the FNPRM. But I think that, you know, it also provides an opportunity, even if it's not, maybe it's with a different kind of set of questions. How can you all promote the good work, the really good work that you all are doing in your communities, right? And something that we raised that is something that the FCC should collect is the low cost offers, right? You know, even before, you know, ACP, various companies had low cost offers in place. How can we make sure that, like, you know, that is like publicly known that you all are doing good work in your communities, right? And so I think, you know, that's what I'm kind of thinking about when it comes to, you know, kind of like affirmative sort of, you know, obligations. And obviously people have had, you know, opportunity to weigh in here, you know, with the commission, and the commission will, you know, take everyone's, you know, comments into account here. And also going back to what I said earlier about the Office of Civil Rights was also included in this FNPRM. And some of the things that we said, we kind of borrowed from the Office of Civil Rights work at FEMA, but we think that an Office of Civil Rights, you know, should focus on, you know, kind of like compliance, right? Creating and reviewing various policies and plans and procedures, you know, at the FCC, and making sure that they're also, you know, kind of engaged in a complaint process and engage in alternative dispute resolutions with various stakeholders. And that's, you know, a lot of what you saw from the public interest community and civil rights community was focused on the commission standing up and Office of Civil Rights in this kind of round of comments.
Just real quickly, to piggyback on Elisa's very good point about publicly available information about the good work and the offerings that providers have, we have the broadband labels. It's great. They rolled out in April for larger providers. They're going to roll out in October for all the rest. And so I think that's, and everything has to be word searchable. That information is going to be submitted to the commission in like a CSV format. So some of this information is already going to be in the commission's hands. And I think that, you know, it's a great way to show all of the good work that broadband providers are doing in the community.
Yeah, I agree with that. I agree with that.
That's a great point, Diana. So in our last 10 minutes, let's turn to the appeals that are currently before the 8th Circuit. Nearly 24 industry groups, including wireless and cable stakeholders, have challenged the report and order in 3 different circuit courts. We are looking at an appeal before the 8th Circuit, and oral arguments are tentatively set for late September. Let's read the tea leaves a little bit, although I know from my time at the FCC and my time at Crown Castle that it's a very dangerous game to try to guess what an appeals court may end up deciding. What are some of the biggest issues that we're going to see in front of the court? And if you'll indulge me, where do you think that the court is going to land?
Well, if I was clairvoyant enough to answer that question, I'd probably be in a different line of business, as much as I love my job and I love broadband. But, you know, for us, this really comes down to what the FCC's order is not what a bipartisan Congress intended. Disparate treatment is going to be a big one. The text of the statute based on makes very clear this is an intentional standard. Other canons of statutory interpretation should take care of that. And if that doesn't carry the day, we believe the major questions doctrine will. I mean, let's think about the IIJA in context. This was a 1,039-page statute. Section 60506 is, I think, about 3/4 of a page tucked into that statute. Broadband is such an important part of everyone's life, the economy of this country, especially post-pandemic. I mean, the pandemic really drove home how important the work that Denny and all the other broadband providers are doing every day is. We don't think it is conceivable that tucked into this, you know, 3/4 of a page provision out of 1,039 pages, that Congress could have intended this kind of sweeping control over such an important sector and every aspect of that sector, from advertising to deployment to service quality to everything else. It just doesn't make sense that Congress would use that kind of general language to delegate such sweeping authority. And we are very hopeful that the Eighth Circuit will agree with that.
And I would just say I am very much so not in the predictions game at all, for good things or for bad things. But I agree that I think that the question about disparate impact and major questions doctrine and kind of Congress's intent is going to be the kind of like core of what is focused on here. But yeah, I'm not going to be in the prediction game here as to what happens, how this plays out.
And I don't think I'll wade in. I think I'm the only of the 4 people on this call, the only one with no JD letters at the end of their title. So probably deeper water than I can get in.
That's fair enough. Before moderating this panel, I did one of the seat at the sitting Federalist Society panels. And so everybody's talking about different Supreme Court cases and everybody gives their predictions on what's going to happen. And I always love to look back and see who was right and who was wrong. So that's why it's fun to try to predict. So let me look to see, we can start taking some audience questions in the last few minutes that we have. Let me just open it up and
And can I just add, Danielle, not on the digital discrimination point, but I know that I just want to flag, and hopefully I don't get in trouble for going off script here, but we're all also advocating for sustainable funding for the Affordable Connectivity Program. The funding is scheduled to run out at the end of this month. That program has helped to connect 23 million households, not just people, but 23 million households. And that's something that we're going to be focused on here. We continue to be focused on at Public Knowledge. And I know the great folks at USTelecom, various smaller providers are also focused on this as well. And, we have the kind of, issue before us as it relates to short-term funding and how we can have funding, for the remainder of 2024 for the Affordable Connectivity Program. But we're also focused on, longer-term funding for the Affordable Connectivity Program, right? Because we're not going to solve income inequality tomorrow. We think it's been a great program. It's got a lot of bipartisan support. So just wanted to flag that for the folks, listening in, that is something that we're working on. Industry, public interest, Republicans, Democrats are advocating for, sustainable funding for this program.
Great.
Elisa,
Thank you
I'm
so
really
much,
glad
Elise.
you highlighted that. And, we appreciate the partnership with Public Knowledge on that. And thank you for flagging how heavily involved we've been on this issue. Again, it is really important. And I think some of this, to kind of like bring this home a little bit, there were so many different parts of the broadband provisions of the IIJA, which took care of or purported to take care of things that the FCC still included in the order, like looking at affordability as part of digital discrimination. We have ACP, and hopefully we'll have ACP again. But so we think that, the IIJA was such a tremendous effort that the digital discrimination aspect is one itty bitty part of it. And it's become so much bigger, I think, than it was ever intended to be. And instead of, worrying about being mired in compliance for your advertising at a sporting event, let's focus on getting ACP refunded and helping make sure that, even though broadband prices in this country are more affordable than ever, they've gone down counter to inflation. I think it's the only industry. Eggs have gone up, gas has gone up, but broadband is down and consumers get more value than ever. It's still going to remain out of reach for some. As Elisa said, there is income inequality in this country. There are people who just cannot make ends meet, and let's focus on getting more money for ACP so that we can keep those people connected.
Thank you both for raising ACP and for those comments. I think that's actually responsive to one of the questions that we have in the queue, which is what, if any, role is there for public subsidies or public funding to support broader broadband deployment and improved service? So I think ACP is a really important part of that. And Denny, do you have anything to add, as a recipient of universal service dollars in the Dakotas, how important are those public subsidies to the provision of broadband?
Yeah, they're absolutely critical. But I always caution people, and I could use BEAD as an example of that, which is it is never a one and done type scenario. Anytime you're looking at broadband deployment, you've got to be looking at what I term to be four abilities. First and foremost is availability. Is it available? Second is, if it's not, how do you get it that way? And that's where the public subsidies obviously come in. Capability is the second one. It's got to be broadband that's capable of providing things. The third item is affordability. If people can't afford to purchase the service that providers build, it's a wasted effort. And then the last one, and this is the one that is most often overlooked in my cautionary tale regarding BEAD and other programs, is sustainability. You're not done once you put this, in my case, put it in the ground. We bury a lot of fiber. And so the public subsidy aspect in universal service funding or other future programs, if you don't look at all four of those abilities, not just one, not just affordability, not just capability, not just availability, but also sustainability, you have to consider all four. So to whomever asked that question, is there a role? There's absolutely a role for all of those items, and a public subsidy in many cases is the only way that will work on a widespread basis.
Okay, great. In the last few minutes, let's just do some closing remarks. If you guys have any closing remarks, final thoughts for the audience, for the commission, for any of the listeners, that would be great.
So from my perspective, thank you so much for this conversation. Denny, Elisa, it's been great having this conversation with you. Danielle, of course, is always an excellent moderator. And I think, from our perspective, let's focus on closing the digital divide. Let's focus on getting these unserved and underserved locations turned up to fiber and other next generation networks. Let's not get distracted by things that really have no proof behind them. Let's build it. Let's build it and get people connected. That is where our focus should be. And we remain laser focused on that, as do our members.
Yeah, and I would just add that, similar to what Denny just said, that, it's not a kind of one and done when we're talking about, closing a digital divide. We talk about all of this funding here through the infrastructure law. There's going to be, a lot more work that needs to be done. And, when I think about the digital divide of today, I think it's going to look different, of course, 10 years, 20 years from now. But we have to think about how, again, we give people opportunity, right? Like right now, we're talking about the fact that folks don't have access to broadband. They may not be able to afford it. They might not have access to devices. But when we get all those sort of issues figured out, then we have to think about, making sure that we're building out the digital equity sort of field and the digital skills sort of field, so that we can make sure that people benefit from the kind of next, technological innovation that is AI, because that's what we're going to be talking about, now and in the future when we're talking about the digital divide. But, as always, great to join you all. And thank you so much for inviting me. So, yeah.
Well, I'd also echo, I appreciate the opportunity to join. I appreciate learning from my colleagues on this call, other perspectives and other viewpoints and other items. I would also focus on the I'll say the availability capability side of this is really the biggest part of the equation that's necessary now. Why I'm certainly understandable of digital discrimination and the negative impacts it would have if I were to believe it was occurring on a widespread basis or even on a limited basis. But I think focusing on the availability will help solve that. And I think the digital discrimination path that we're on right now is perhaps unnecessary noise in a larger project. So thank you.
Well, thank you guys so much for a thoughtful discussion. It was wonderful having all three of you with us, and I will turn it back to Kayla to close us out.
I'll echo those thanks on behalf of the Federalist Society. Thank you so much for giving us this portion of your days and sharing your expertise and insight. Thank you also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.